Hey, guys, how's everybody doing today? It looks like it's a fabulous day here in Central Florida. Oh, we got some exciting stuff to talk about today. So, if you give me about 2.5 minutes, we'll get into it. See you guys in a few.
Yeah, the mice and Mike inside my night. Yeah. Talk time with Mr. Coop. Daylight's breaking coffee up. Click that stream, let's fire it up. Morning crew already rolling deep. I'd imagine that with the good vibes keep. Screens glow bright, it's go time now. Mr. Coop's here and he's shutting it down. Big laugh, straight facts, nothing disguised. Countdown hits and the camera shine. Red light flashing right on time. The mic is hot, the talk's alive. Mr. Coop bringing the morning drive. Say your piece, give it all you got. Wake the whole world cause the mic is hot. Yeah, we sip that brew, settle in our spot. Conversation flowing while the mic stays hot. He scans the chat with a careful glance. Calls it real, gives everyone a chance. Keep it cool, keep it clean. Step too far, he'll cut the scene. Whoa, yeah. Stories rolling, punchline land. Morning crew, feeling grand. From deep discussions to laughing loud. This right here is our kind of crowd. No cue cards, no holding back. Just real life talk on the morning track. Hands up high, let the energy fly. Everybody tune cause the mic is high. Yeah. Talk times on the vibe won't stop. Mr. Coop turning it up a notch. Speak your truth, bring what you got. Truth meets laughter when the mic stays hot. From the first hello to the last coffee pour, we're locked in strong. Wanting more, wide awake from the jump. No lie, morning feels better when the mic is high. Good morning's flying, no call out. Every voice counts in this crowd. Turn it up, don't miss your chance. Step right in and join the dance. So the mic is hot, the show's in gear. Mr. Coop keeping it real right here. Wake up, fired up, hit your stride. Everything's brighter when the mic is high.
Hey, good morning, all you fabulous people out there. Yes, it is Friday.
Good morning, Americans. It's Friday.
All right. We're going to have some fun times today. So let's get it out of the way right off the bat. What is the temperature in sunny Florida today? Oh, let's see. Oh, it's typical. Ay. 89 degrees at 11 o'clock in the morning in Central Florida. I hope you guys are all staying cool, wherever you're at, staying safe wherever you're at. Yes. It's one of those days. But it is Friday, and tomorrow starts the weekend. Well, tonight starts the weekend. Anyway, I hope each and every one of you have a fabulous day today. Let's get into some good mornings. How you doing? All right, we got Mr. Kiko in the house. Good morning, young man. We got Tammy P. Good morning, young lady. We got Big Dirt. How's it going, my friend? How's it going? Charlie Sugar. What's up, buddy? Yes. Miss Colleen, good morning. Nancy, good morning. How are you? Miss Tracy Spencer, how are you doing today? Oh, good morning there, Mr. Coop and everyone. Dee, I'm not sure if Dee's going to join us today or not. I've got her in the thumbnail. I've got her in the title, but I'm not sure. She's busy right now. So if she's got the link, if she wants to pop on, she can. If not, hey, it's okay. All right. Who else we got in here? Rugby. How you doing? Glad to have you. Oh, who else do we have in here? Yes. Scrolling. Andrea, good morning. How are you, young lady? Patty, good morning. Howdy, y'all. Right back at you, girly girl. Yes, we will be going over Randy's filing from the deposition on Tuesday. It's 19 pages. It's pretty interesting. I haven't got to read a lot of it, but I know Dee read it, and she was telling me quite a bit about it. Quite a bit about it. It is funny. It is funny. That's why I'm kind of hoping that she shows up, because I know she read it, and I know it's hilarious coming from her. Linda, good morning. Al Walker, good morning. How are you guys? Quill Worker, how are you? Kim, good morning. Wow, we've got 114 of you fabulous souls in here right now. So please, if you don't mind, hit that like button. Teach old ScrewTube to send us out into the interwebs. And everybody on replay, please hit the like button. It's free. It don't cost anything. All right, all right, all right. What do we got? We got Kim in the house. Good morning, Kim. How you doing? Why didn't that come up? There it is. Now it's up. All right, Marion Fields. Good morning, young lady. Young lady. Bingo. How you doing, Bingo? Yes. Good morning.
Bingo.
All right, Sister Sal. Good morning, young lady. Good morning. How are you? Kat, how are you doing? How are you doing? Good morning. Good morning. Welcome, welcome, welcome. I see some new faces in the chat. Welcome aboard, guys. Welcome aboard. Matthew, what you got to say? If Lynette is filling out court documents, would they be considered legally void because she's not using her real name on any of them? Then it's considered fraud on the courts. Well, I don't know, Matthew. You got a point there, my friend. You got a point there. I can kind of see that. I'm not 100% sure, so I can't say one way or the other, but you got a good idea. It could be. Greg, good morning. How you doing? Good morning, Mr. Coop and D and friends. Greg says, good morning, Greg. Who else do we got in here? And there's Sister Sal. Good morning, Sister Sal. Shanemesis. Good morning, young lady. How you doing? Shanemesis. Always glad to have you, really, girl. Yes, always. Teresa, good morning. Yes, happy Friday. Happy Friday. Yes, yes, yes. Debbie D, how you doing, girly girl? Good morning. Good morning. Harry, good morning. How are you, my friend? Oh, Al Walker, did you get the latest court document from Fed case on bankruptcy case? I seen it. Listened on Pacer Monitor. When will the judge issue her ruling on the deposition? I don't know. I haven't seen it yet. But stuff comes in all the time. I will keep my eye out. I know Al, he's very vigilant on that. So he will let me know when it's in. Who else we got in here? Tree God, good to see you. It's been a minute, brother. Good to see you. Good to see you. Christy, good morning. Good morning. How are you, young lady? Oh, and there's Mr. Al Walker again. Ball Python King. How are you, my friend? Good morning. Good morning. Who else we got in here? There's Colleen. Good morning. Good morning. Yes, everybody's rolling on up in here. Oh, Benz. Okay, we'll just call you Benz. How's that? Good morning, everyone. They say yes. Good morning to you too. All right, all right. Who else? I can't pronounce your last name, but we'll just go right there. Casa, yeah, Casa, Garcia Casa. Yeah. All right. Good morning. How you doing? How you doing? Flip. Good morning. Good morning. Grammy Fox, how you doing? How you doing? Oh, who else? You're testing me, CK, over in the Rumble dungeon? Yes, guys and gals, if you are not following us on Rumble, you need to be, because just in case something happens to YouTube, boom, we go over there. Yes, we do. So if you're not following us, if one of the mods will be so kind as to post the link. I don't know why I'm asking the mods. I can do it. I'm right here. Got it right here. Accessible. Now this isn't to the channel, guys, but it is to the stream that we're going through right now. So hey, join us over there. Follow us. Give us a follow. Yeah. All you gotta do is click the link and then click up to the top right-hand corner where my little picture is. It should take you straight to the or straight to there, and then you can just join from there, I guess. Oh, you can join from here too. All right. Cool beans. Cool beans. Just Jolanda, how you doing? Good morning. Good morning. Saints fan, good morning. Come back here. Where are you at? Good morning, Saints fan. And Round Man, good morning. How you doing? Ronnie, good morning. How you doing? How you doing? All right. Iced tea, how you doing? How you doing? Oh yeah, I do. I drink iced tea every morning right here. All through the show. And it's good. Southern sweet tea. Yes, it is. All right. Who else we got in here? Oh, Terry, good morning. Good morning. Bill, good morning. How you doing? How you doing? Devils fan, good morning, Mr. Coop. How was your date with Squat Pump? Oh, did I go on a date that I don't know of? That's news to me. Oh, Jolanda says, hey, hey, Colleen, Jolanda says, untie my tongue. Right on. So now we are caught up. We've got 159 of you fabulous folks in here. So if you don't mind, please hit the like button. Teach old screw tube to throw us out into the interwebs. And if you are watching on replay, please hit the like button. Ship us out to the interwebs. All right. As far as I know, guys and gals, we don't have any ramblings from a mad woman today. So, the Wookiee, good morning. Good morning, mods and chat. Hope you're all having a great day. I'm having a fantastic day. Big Al, how you doing? How you doing? Turn the fan around. I beat you to it today, Round Man. I already got her going. I already got her turned around. Yeah. Oh, did I turn my speakers back onto headphones? Yes, I got it all done. I shouldn't be sounding like I'm in a can. Nope, I'm sounding normal. So yeah, everything's working copacetic today. Yes. I liked and shared, Sister Sal said. Thank you so much, Sister Sal. It means a lot to me, girly girl. Oh, Big Al said, or Al says, Mr. Coop, for informational purposes. Yep. Waiting for document 130 on Pacer over Randy's motion in the bankruptcy, or document 229 in Fed case 2 over Lynette's latest bankruptcy depot. All right. Thank you, Al. Thank you, my friend. Thank you. Oh, Devil Span, what do we call Lynette if she doesn't know her own name? Spacey Lacey, from what I understand. I think that's what we're supposed to call her. I don't know. It could be. What is status of monetization? Well, as of right now, I have 8 days before I can reapply. So, when the 20th rolls around, I can reapply, and whether they give it back to me or not, I don't know. I'm hoping they do, because my channel has been completely revamped. Anything that went on before January 1st of 2026 is gone, because I didn't want to spend hours and hours and hours of editing thumbnails, descriptions, and all of that crap. They were all live streams. The live streams quit getting traction about 48 hours after they're done. So it doesn't matter if I have them there or not, but I do have the majority of them still on Rumble. So if anybody wants to catch up on last year's stuff, they can do that all on Rumble. But as far as my monetization goes, next the 20th. So I think it's not this coming up Monday, but the following Monday, I can reapply. Hopefully they'll give it back to me, because everything from January 1st of 2026 to now, everything's different. The whole channel is different. There's different thumbnails for every single video or stream. There's descriptions, there's titles. There is no reason why they shouldn't remonetize me, but we will see. I don't know. Don, how you doing? Good morning, Mr. Coop. Good morning to you too, Don. How are you? Let's see. Let's get caught up. But as far as monetization, I am fully monetized on Rumble. Okay. They have Rumble rants over there. They have subscriptions over there. I am monetized over there. Mama Coop was so wonderful. She set up all of the banking stuff for me. So it's going across the bottom of the screen. There's a Cash App, there's a Venmo, and then I have PayPal pinned in the comment section. If you go to the description of this video or this stream, I also have the coffee link in there as well. If you guys would like to donate to the channel to help the channel out, that's fine. If not, that's fine too. You just being here is enough for me. I like having fun with you guys. Yeah. All right. Let's see. Don, what you got to say? Better finally broke a migraine. Good. That's good. I'm glad to hear that. That's one thing I can't stand are migraines. Oh, those things are a nuisance. They're painful. Devil's fan, I want to be a fly on the wall when the sheriff comes and they kick them off the property, Devil fan says. Right? Well, you could always go across the street and visit Tubetown while it's going on. I'm sure you can sign the book over there and have a nice chuckle at what you see. I mean, Travis has got that place decorated up. Pretty cool. Pretty cool. Oh, Al says more information. This is interesting. 2 new documents were filed in Levy County, Florida, in the Granger case. More emails were sent to the court. Oh, really? Really, Al? I saw you put something in that channel this morning, but I did not look at it. I have not downloaded it yet, so I will take a look at that when we get off stream. That's going to be interesting. Yes, it is. Yes, it is. Saints fan, I watched the members only from Jeremy with Megan and Tug. Crook isn't a property owner, according to what they said. I can't say 100% because I haven't seen any paperwork on it. The only thing that I have seen is what's on the county website for the tax appraiser's office. That unfortunately says 50-50. Now, what's on the deed, I don't have any idea. I don't know. I haven't seen it. I can only go off of what Jeremy and Tug and Megan and all them have said. So I really don't know. Sister Sal says, horrible. I hate migraines. I do too. Mama Coop has migraines every once in a while, and she has some pills that the doctor gave her, and she tried giving me a couple of those here. I don't know. It's been a couple of months ago. And man, I'm going to tell you, those freaking things, I'll never take them again. My whole face felt like it was tingling. I didn't like that at all. It was miserable. I would have rather just went and laid down with the migraine than take those things. It did kick the migraine, but I did not like the effects of it at all. What you got to say, Jim? Good morning, Mr. Coop, and happy Friday to everyone in chat. Well, happy Friday to you too. Janice B, good morning, Mr. Coop and chat. Good morning to you too, young lady. Good morning. Oh, Tor Hill, good morning, young lady. Good morning, Coop and chat, she says. All right, glad to have you all the way from Norway, guys. Wow, that's a long ways. That's a long ways. Yes, it is. Glad to have you. All right, let's go see what we got to talk about today. I didn't even pull up my PDF, so I've got to get that pulled up real quick so we have something to talk about. That is in the bankruptcy. Yes, it is. Tang. Scroll all the way down. I think it is 129. I do believe. Yes, it is. And it is 19 pages long. Now, did I redact this thing? I better make sure before I start diving into it, to make sure everything is, yeah, I did redact it. All right. Cool beans. D actually told me yesterday, or not yesterday, Wednesday, that I had missed an email that I needed to get it redacted, and she was right. I did. Coop missed it. All right. Matthew, come back here. Matthew says, question. So are they still sending emails, or are they ones that haven't been released yet? If they are new emails, then they in more trouble with Florida Supreme Court. I don't know who's sending the emails, Matthew. Big Al or Al didn't say who it is sending the emails. Maybe it's Bubbles. I don't know. I don't have any idea. I From what I understand, all of these emails that were sent that got Bubble in trouble, I think were sent in the Granger's case. But it was talking about Jeremy Hales. It wasn't talking about the Granger case. Okay, so all the emails that were sent, he was putting motions into his emails regarding Jeremy Hales and stuff that was outside the scope of the Granger's case. But Jeremy and Randy, that they all filed sanctions or whatever it is with Grove against Bubbles for what he was doing. Now I could be mistaken on that. I'm not 100% sure, but I'm pretty sure that's because I was always wondering why Jeremy was going after Bubbles when Bubbles was doing this in the Granger's case. But then I got to read the emails, and the reason why is because Bubbles was putting all these motions that were regarding other cases other than the case that at hand, which was the Granger's case at the time. I could be wrong, but that's the way I took it. That's the way I believe. But we will find out. All right. What do we got here? M.M. Marsh, good morning. How are you? Tammy comes in hot with a comment. What you got to say, Tammy? It comes down to what LP real government legal name is. She did not sign the deed with the right name. It all can be void. Oh, gotcha. I don't understand what's the deal with all of these names. I mean, you guys have been following this case for over 2 years now, and you've got so much stuff out there that she has changed her name on. If it's not on your driver's license, how can you put it down on federal court documents? That's what I can't understand. So if all of those names, Michelle, Lynette, Alexis, or whatever her full name is that she calls it, if that's not on her driver's license or on her birth certificate, why is she using it on legal documents? I don't understand that. I would think that you could get in trouble for that. But hey, I don't know enough about the legal system when it comes to that anyway. But what I don't understand clearly is why that you would give yourself names other than what your parents gave you, especially putting them on court documents. It doesn't make sense to me. Oh, who else we got in here? You're testing me. Al Walker says the emails should be unlocked within the next couple of hours, and we will figure out what the heck is going on. Well, thank you, Al. Thank you, my friend. Quill worker in Florida. A person can be on a mortgage, but not on the deed. The deed gives legal ownership, and the mortgage is a loan. Did they mortgage the property? No. From what I understand, the property was paid for outright. It was not mortgaged. It is completely 100% paid for. From what I understand. I don't know, I can't be certain. I haven't looked at the deed and I wasn't sitting right there beside them. But from what I understand, it is not mortgaged. It is paid for in cash. Okay, Roy, good morning. How you doing, my friend? Oh, good morning, everybody saying good morning. Janice B, Elemental P, changes her name every time she runs. When her grifting is found out by the people she has scammed. Right? I'll take your word for it, Janice B. Yes, I will. All right, what do we got here? Quill worker, I heard they paid cash. Right, Saints fan? I'm pretty sure they paid cash for it. J-Raid, incoming J-Raid. Good morning, Wally. How you doing? Rob Pate. Granger case is the one and only case Jeremy is not party to. That is why Paint Chips can get in trouble sending Hales related motions emails there. I I think, if I'm not mistaken, Rob, it was Bubbles that sent the emails. Now, the emails that Al's talking about right now, I don't have any idea who sent what. He just states that there have been more emails sent. So we will find out about that eventually. Al seems to think that they'll be dropped with here in a couple of hours. I probably won't go over it today. More than likely, I'll go over it tomorrow. Today, we're going to go over Randy's motion, document 129, that he filed the day of the deposition debacle. Yes. Oh, Matthew, I wonder if she has done this in the past with over 40 different names. And the past, if so, could she be liable versus our vexatious litigant? I don't know. I don't know. Vexatious litigant, I think that comes into play when you're filing vexatious lawsuits against people. But as far as using multiple names, I don't know what that would fall under. Fraud, maybe? I don't know. Mr. Landfill, how you doing? People do that to get away with fraud, Mr. Landfill says. Right. Oh, Kelly says, JJH Raid. Good morning to all you JJ Bean folks. Good morning. Oh, he was on a tirade today. He was having fun. Oh, my goodness. Yes, he was. The stats, good morning. It looked like there was a credit taken on the property by Elemental P. Oh, so you're saying that maybe there was a mortgage taken out or a loan taken out against the property? That could be. Oh, Flip, what you got to say? Got to use other names to grift, right? Most definitely. All right, who else we got in here? Rolling. Good morning, everyone. Like every day, getting ready to take us all to the gym. All right, Linda. Well, you have a safe travels there, girly girl. Keep us lurking in the background while you do your workout. Yeety McYeedison, how you doing? Good morning. How are you? Man, a lot of new faces in the chat today. Welcome aboard. Photo lady, good morning. How are you doing? Randy. But why is Hales and Randy always question about name and nerve gets to any real question? I don't know, Randy. I don't know. I don't know what Randy's doing. I've never listened in on any of his cases. All I can go by is what information Jeremy has given us. So I'm not sure. Let me read that again. But why is Hales and Randy always question about name and never gets to any real question? Well, when it comes to depositions, lawyers already have the answers to the questions they're going to ask. They're just asking the questions to see if the person will lie to them or not. Okay, so that's why I don't understand why Lynette doesn't just answer the questions. This was brought up the other day. Most of the stuff that she's asked, all she's asked is for a yes or a no. She's not being asked for a complete breakdown. They just want to know yes or no to the questions. That's it. But that's where these kind of people, their entitlement, their self-entitlement has gotten them to the point to where they don't think straight. All right. This is just my opinion. They don't think straight. They think everything is a confrontation. They think that everybody's out to get them. Well, a deposition is there to uncover the truth. And if it gets a little heated, it gets a little heated. That's just part of it. If you don't want to be in a deposition, don't do stupid shit to get sued. Don't do stupid stuff. That's how that works. You guys got to remember, and I'm pretty sure all of you know, when it comes to this bankruptcy and it comes to the thumbnail case and the Trespass 5 case, these are all cases that she brought forth. She took these cases out against these people and for herself to get debt relief. So she needs to be answering this stuff. It's going to come back to hurt her in the long run. Playing stupid does not get you out of a lawsuit. Oh, what do we got here? They said they paid cash for the sale of the Northport property. Right, Tony. From what I understand, they got like $130,000 they took away from the Northport property. They split it in half. I think each one of them walked away with about 60 or 65,000 apiece. Now, up until the deposition the other day, I didn't know that Lynette paid for all the property out of her portion. I was always under the assumption that the two of them paid for half and half, 11,000 from one and 11,000 from the other. But according to Jeremy, according to what was said, she said she paid for all the property. So I don't know. We a lot of this stuff is all fresh and new coming out. So we're learning a lot of new stuff here lately. Oh, hey, Joe, what you got to say? Authorities will have to look into all kinds of fraud now, Social Security, Medicare, SNAP, etc. How much money is she really bringing in? Well, you take Melissa over on Facebook. I don't know if you guys know who Melissa is, but Melissa has probably the biggest file system database set up on all of this stuff. She's got everything almost since day one from these chuckleheads. And throughout all of this stuff, all of the paperwork that Lynette has turned in that has financials on it has been added up. Okay, they bring in close to $4,000 a month in just money. Okay, that's not counting the food stamps that they get. Okay, on the latest bankruptcy form, they're showing $750. Now, if that's an accurate count, I don't know, but she lists 350 on one line and then she lists 400 on another line. I don't know if they're together or if they're separate. But at this point in time, it's like $750. So they're well over $4,000 in food stamps and money a month. So why this barn dominium hasn't been worked on the whole time they've been on the property blows my mind. I hope that answered some of your questions. I'm getting way behind here, guys. Tiny, how you doing? In Jeremy's coverage, he did mention Lynette owning property in Northport that she sold to purchase the Otter Creek place. Right. She had a remodeled house. Now, this is one thing that I did learn here recently. It's been a couple of weeks ago. They literally, and this came from Michelle. This came from Lynette herself. It was a government grant that they got to remodel that house in Northport. As soon as they got the house remodeled, shortly thereafter, they sold it. So in my mind, if you got a grant from the government to rebuild the house or remodel the house, shouldn't you have to pay that grant back? I don't know how that works, but it sounds like some schemy shit to me. I'm going to go ahead and get caught up, guys, because I'm way behind on my chat here. So if I miss over anybody, forgive me, but I'm going to get caught up here real quick. I know there's a bunch of questions that I've missed, but I will come back to them. What you got to say, Stats DR to most? It's funny. Someone thinks I don't belong over here. I've been with my friends all over these channels and still have friends in her chat. She cannot control peeps holes, right? It's getting louder, right, Stats? Well, hey, you've always been very polite in my chat. You're welcome here anytime you want to be here. And if anybody has a problem with it, they can come talk to old Coop. You've always been a very nice person in my chat, so you are welcome. All right. Hey, French Psycho's over in Rumble Dungeon. Have a good one there, French. Glad to have you. Spawn's in the house. Good morning, Spawn. Spawn Trooper, good morning. And while you are in the fridge, help yourself to a Dr. Pepper, DR says, right? Oh, Rob Pate, what you got to say? Tony, I think what they were talking about was LP may have used Third Purgatory to, on the day on the loan. Okay, control. Damn it, I'm getting tongue tied. Okay, there you go, Rob. Okay, let me get caught up again. All right, get back down here, man. You guys are burning me up today. It's great. It's great. It's fantastic. Faves, how you doing, girly girl? Glad to have you. Glad to have you. All right, all right, all right. Who else? Where's another question we can get to? Yeety, 2L's was really spitting out your name and the stats. Oh, was she? Oh, that's where that came from? She was all over stats? Oh, okay. Well, like I said, stats has always been good in my chat. She's welcome. Goes over to the fridge, grabs a cold drink, and kicks Spawn Trooper out of the fridge because peepholes, right? Right? All right, I got somebody messaging me. What do we got going on here? Oh, come on, phone. I don't want that. Why is that doing that? Yeah. Okay, it's Matthew sent me something. Share Google. Okay, thank you, Matthew. I'll look at it here shortly, my friend. Who else we got in here? Oh, okay, gotcha. All right, all right. Oh, what's up? Let's give you a little shout out. Yeah, I heard him last night. I heard him. Spawn. Thank you, my friend. Thank you. Thank you. Where did it go? That's Fabes saying howdy, howdy. Everybody's saying howdy, howdy. All right. I think we're going to mumble right into this. I've been going for about a half an hour. I need to start looking at this here document. So let's get this thing pulled up on the screen. Okay, there it is right there. There is no sound, so here we go. We're gonna run it. Hopefully Dee will pop in shortly. I'm not sure. She's still taking care of some business. Oh, yeah. All right. Let me get my eyeballs straightened out before I start trying to read this stuff, guys. Oh, yeah. Here we go. Motion to compel. Resumption of deposition for the sanctions. All right. Creditor Jeremy B. Hales, by and through undersigned counsel, respectfully moves this court pursuant to Federal Rule of Bankruptcy Procedure 7030, incorporating Federal Rule of Civil Procedure 30B2 and 30B3A, Federal Rule of Civil Procedure 37A 3B, for an order. 1. Compelling the resumption of the deposition of debtor Lynette Lacey Michelle Spacey Lacey Preston under proper conditions. 2. Imposing cost, shifting sanctions, requiring the debtor to pay the creditor reasonable attorney fees, court reporter appearance fees, and time spent during the motion. And 3. Imposing further sanctions, as this is the second deposition that has failed to process to completion due to debtor's disruptive conduct. In support of this motion, the creditor states as follows. I guess that's letter I. Okay. Introduction. This is the second time the debtor has failed to complete the deposition due to her own disruptive conduct. On July 7th, 2026, the debtor deposition was reset and commenced at 8:30 a.m. despite the good faith effort of her own counsel to control her behavior. The debtor repeatedly interrupted the undersigned while questions were being asked, refused to allow questions to be completed before answering, and thereby implied, delayed, and frustrated frustrated the fair examination of the dependent or in violation of Florida Rules Civil Procedure 30B2. 3 breaks were taken off the record so that debtor's counsel could attempt to correct his client's conduct. All right, cool. So they got 3 breaks trying to tell her to be good. Oh, and on the record, the debtor's own attorney respectfully or repeatedly instructed and reminded the debtor to stop interpreting and allow questions to be completed before answering. Well, that's I don't know why anybody who would do that. It floors me. The more you mess with a lawyer, the more he's going to mess with you. She needs to just answer the questions yes or no and move on. This stuff would go by so much easier for them if they would just behave. The debtor bypassed her own attorney's instructions and continued to continued this disruptive behavior. At 11 a.m., the undersigned suspended the deposition pursuant to federal law, on the grounds that the deposition was being conducted in bad faith. Right on. The court has already granted creditor Jeremy Hales entitlement to sanctions against debtor for her untimely and unjustified motion for protective order that caused the prior deposition to be aborted. Okay. The pattern of obstruction requires judicial intervention to ensure compliance with discovery obligations and to compensate the creditor for the repeated waste of time and resources. Wow. This is going to be interesting waiting on this judge to rule on this. Now, as far as the first deposition that she never showed up to, I know that there were sanctions and lawyer's fees that were supposed to be imposed, but I have not seen any paperwork on that yet, so I don't have any idea if it has been officially sanctioned. Correct me if I'm wrong, chat. I really don't know, but I do know that there has been talk that she did get sanctioned and attorney's fees. I don't know if there's a final decision on that or not. We will find out, I'm sure. But this just what happened on Tuesday is going to compound that price tag tremendously. It's going to add a lot more to it. Oh, a transcript of July 7th, 2026 deposition is being prepared and will be provided to the court as soon as it becomes available. The transcript will demonstrate the repeated interruptions, the inability of opposing counsel to control his own client, and the justification for suspension under rule blah blah blah. Statement of facts. Wow, here we go. Procedural background and prior discovery abuse. Oh, wow. That even sounds ominous, guys and gals. Woo! Let me tell you. Oh, let's see what we got over here. What you got to say, Tammy? Mr. Coop, normally all sanctions and fees are done at the end of a case. Right. But there should be some paperwork discussing whether or not it will be approved. But I don't know. We will find out down the road. There should be something from the judge ordering that, yes, the sanctions are going to be opposed, but when they get opposed, who knows, or not opposed, but approved. When they get approved, who knows? But there should be something saying that the judge said, okay, she didn't show up, so hey, you're going to get nailed for it. But yeah, I agree with you, Tammy. I agree. That's from what I've read. No, I wasn't. Sister Sal's talking to Faves. All right, let me get caught up. Again. All right. And on April 28, 2026, the creditor, I'm tongue-tied like crazy today. properly noticed the debtor's deception to take place on May 26th or 27th, 2026 at 8 a.m. at Levy County Courthouse in Bronson, Florida. On May 25th, 2026, only 2 days before the scheduled deposition, the debtor filed an emergency motion for protective order seeking to postpone or cancel deposition. In paragraph 6 of the motion, the debtor admitted that the medical procedure creating the alleged scheduling conflict was arranged months in advance. The debtor failed to appear at the scheduled deposition on May 27, 2026. This court denied the debtor's emergency motion for protective order and found that the motion was untimely, not substantially justified, and demonstrated a lack of diligence. Oh, wow. The court found that the debtor had months of advanced knowledge of the scheduling conflict, yet waited until 2 days before the deposition to seek relief, which was inexcusable and the product of delay and poor planning. The court further found that the debtor's conduct cannot be considered substantially justified under Rule 37 standard. Wow. So the judge told her point blank, you messed up. We're going to take care of this later. Oh, yeah. Rules of chat. All right. Mercedes is on it. What do we got here? Okay, we'll get back over here. The court awarded entitlement to attorney's fees and cost to the creditor under Federal Rule of Civil Procedure 37, blah, 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 and Rule 37B, and ordered the debtor to appear in person for her deposition on or before July 9th, 2026. The court found that sanctions serve important purpose, including deterring similar conduct. Well, it didn't deter shit, did it? By other parties, penalizing the offending party for disregarding discovery obligations and vindicating the integrity of the discovery process. So all of the crap that she said about John was no excuse. She should have showed up for her deposition. That's how that works. On July 7th, 2026, deposition and disruptive conduct. In compliance with the court's order, the party agreed to reset the debtor's deposition for July 7th, 2026. The deposition commenced at 8:30 a.m. The debtor's counsel, Saranrap, Esquire, appeared and represented the debtor. Oh, from the outset of the deposition, the debtor refused to stop interrupting the undersigned while questions were being asked. The debtor repeatedly interrupted the questioner and did not allow questions to be completed before she started answering. Well, that's just who Lynette is. But anyway, from what I understand, she actually admitted that she was doing this stuff on purpose. Now, whether that's true or not, I don't know. That's just what I heard. Oh, Big Al, good to see you, my friend. I do believe the stuff she said about John got back to somebody because they got a visit from the sheriff and CPS. Now, that's what I've been hearing in the Rumblevine, but I don't know. I hope that nobody in my chat has called anybody. We tell people repeatedly, do not contact or interfere with anybody involved in any of this. Let Jeremy Hales take care of it. Oh, but yeah, I heard the same rumblings there, Big Al. I don't know. Maybe not. Now, I will leave that to Mr. Coops Mods. I don't know what happened. Something going on? Mods can handle it. Like, or talk about, you will be welcome here. Yeah, everybody's welcome here. You guys all know I only have one rule: be kind, or be good, or be gone. That's it. That's it. Lana is done by all accounts to this. Or am I misunderstanding it? No, she's in some hot doo doo, Spawn. She's in some hot doo doo. Just put it that way. She's in trouble. I'm just being a bossy chatter, Fave says. All right, Fave. Okay, don't scare me like that. Don't scare me like that. All right, now I done lost off where I was at. Debtor repeatedly interrupted. This is the same disruptive behavior the debtor engaged in during a prior deposition with the undersigned in a state court matter, demonstrating a pattern of obstruction. Oh, wow. Breaks were taken often are taken off the record so the debtor's attorney could attempt to control his client's conduct. In addition, on the record, the debtor's attorney repeatedly reminded and instructed the debtor to stop interfering and allow questions to be completed before answering. Despite these repeated, right there, guys, repeated instructions from her own counsel, counsel, the debtor bypassed her attorney's directions and continued to interrupt the undersigned. Pattern of behavior, guys. Pattern of behavior. That's how it works. That's how it works. All right, what happened over here? Let me take a second right here, guys and gal. Oh, wrong one. Oh, we're gonna. All right. Let's see. We stopped right there where the debtor's conduct made. All right. The debtor's conduct made it impossible to conduct a fair examination. The constant interruptions prevented the undersigned from completing questions, establishing a clear record to obtaining responsive answers. Okay. The disruption was deliberate, persistent, and in defiance of both the undersigned's request and the debtor's own attorney's instructions. Yeah, it's because these people are so self-entitled. They have been emboldened to the point to where they know they're not going to get in trouble. You can sanction these people. You can fine these people with attorney's fees, and none of it is going to do any good because they're not going to pay it. They're going to ignore it. The only thing that's going to make this click in these guys' heads is to throw their little behinds in jail for contempt. That's it. Anything, other than throwing them in jail for a few days, they don't care. I mean, this has been going on for what? Close to 3 years. And she already owes $3,350 in Ohio that we know of for a fact. Still unpaid. So they don't care. She's not going to stop, not until she's forced to by the courts. Now, will the judge make them? Will the judge put her in contempt and throw her in jail? I don't know. Based on what we've seen over the past few years, no judges have done anything to any of them. They allow them to just keep on going with their ridiculous behavior. All right. At 11 a.m., after 2.5 hours of repeated instructions and obstruction, the undersigned moved to suspend the deposition pursuant to Federal Rule of Civil Procedure 30 on the grounds that the deposition was being conducted in bad faith. Rule 30B, blah, 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 provides that at any time during a deposition, a party may move to terminate or limit it on the grounds that it is being conducted in bad faith. Right. Okay. Okay. We got that. All right. All right. Or in a manner that unreasonably annoys, embarrasses, or oppresses the dependent on the party, deponent on the party, right? Gotcha. 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 And that if the objecting party so demands, the deposition must be scheduled for the time necessary to obtain the court order. Okay, here we go. The undersigned demanded suspension of the deposition pursuant to rule. Okay. Uh, the rule explicitly requires that upon such demand, the deception or deposition must be suspended for the time necessary to obtain a court order. The deposition was accordingly suspended. Yeah, accordingly suspended at approximately 11 a.m. A transcript of the deposition is being prepared. He's repeating himself from earlier. Okay, a transcript of the deposition is being prepared and will be provided to the court as soon as it becomes available. The transcript will demonstrate the justification for suspension and the need for sanctions. Oh, number 3 here, legal standard. Wow. Let's see what the chat's got to say. Oh, I agree. What you got to say, DR? Come back here. Let me read it. I agree. If LP is lying on Crook, I hope he does the right thing and leaves her. What she is claiming is disgusting. I know he won't, but he should. Well, she's been saying this stuff for years and years and years, DR and stats. And he hasn't left yet. I mean, people have shown her own words many, many, many times, and he is still there. So I doubt very seriously he's going anywhere. He'll just keep taking it and taking it and taking it. That's just my opinion. Marsh, come back here. Ooh, come back here. Come here, Kara. Her getting by with her behavior in front of a judge grudge is what started this. Yes, exactly. Exactly. She's been given so much leeway in everything that she does. She just gets worse and worse as time goes on. I see the only way this stopping is if one, the judge is sitting in court and Lynette sees this, she will stop. Or if she doesn't stop, the judge will put her little butt in contempt and have the bailiffs let her sit in jail cell for a little while. That's the only way this is going to stop. If the judge is not in the courtroom or she's not put in jail, she's going to continue down this road until the day long. I mean, it's going to keep going. Oh, let's get caught up again. Man, you guys are running that chat like crazy. I love it. I love it. I love it. Okay, legal standard, Federal Rule of Bankruptcy Procedure 7030 incorporates Federal Rule of Civil Procedure 30. Federal Rule of Bankruptcy Procedure 730 provides that Federal Rule of Civil Procedure 30 applies in adversary proceedings in bankruptcy. Okay. The Federal Rule of Civil Procedure, including Rule 30B2, Rule 30B3, and Rule 30BA, are therefore fully applicable to depositions in this adversary proceeding. B, Rule 30B2, authorize sanctions for conduct that impedes, delays, or frustrates the fair examination. Federal Rule of Civil Procedure 30B2 provides that the court may impose and appropriate sanctions, including the reasonable expense and attorney's fees occurred by the party or by any party on a person who impedes, delays, or frustrates the fair examination of the deponent. Okay, deponent. All right. The rule is designed to ensure that the depositions proceed in an orderly manner and that obstruction or obstructive conduct is deterred and punished. Right. I don't see why this judge will not will not do something. This right here, this motion right here, I think is the most in-depth motion that Randy has filed as far as her behavior in these depositions go. This is, we all know that she has done this since Judge Grudge days. That's back in what, 2023, I think. But I think right now this is the most in depth that he's gotten. And the bad part is it's all her. She's done it all. She cannot question it not being done. She has done it. She can cry all she wants about, oh, he was being a mean man. Oh, he was being very mean to me. No, bullshit. He was asking you questions. I mean, her own lawyer jumped her butt 3 times off the record and continued to tell her to just answer the questions. And she still kept on. It goes back to, remember guys, back in, what was it, May of 2023 when she got a cease and desist? Y'all remember that? She got told to stop. And she got worse. She was told no. Even before that, she was told no at the meet and greet. I think that was in 2021 or 2022. I can't remember the exact year. She was told no about putting up a donation jar at Jeremy's meet and greet. That's what started all of this bad behavior. And then she gets a cease and desist. And she just continues to get worse. And nobody does anything to them. She's broken the protection order. Okay, he got a protection order in Ohio. All right. She was deemed to be a stalker and a harasser. So she got a protective order against her. They broke the protection order twice and was convicted of it twice. And still yet, nothing gets done to them. They get fined, but they don't get in any real trouble. Money, they don't care. They don't have money, so they don't care how much money gets fined against them. They just continue with their bad behavior. It's insane. It's absolutely insane. Like I said, the only way this is going to stop is if some judge somewhere puts their little behind in jail for it on contempt. That's the only way it's going to stop. C, Rule 30B3A permits sanctions, supervision, or no suspension, and requires the court order to resume. Right? Federal Rule Civil Procedure 30 provides that anytime during the deposition, the deponent, or a party may move to terminate or limit it on the grounds that it is being conducted in bad faith or in a manner that unreasonably annoys, embarrasses, or oppresses the deponent or party. Right? Gotcha. If the objecting deponent or party so demands, the deposition must be suspended for the time necessary to obtain an order. The court may order that the deposition be terminated or may limit its scope and manner. If terminated, the deposition may be resumed only by order of the court. All right. D, authorizes motion to compel examination and sanctions. Federal Rule Civil Procedure 37 provides that a party seeking discovery may move for an order compelling disclosure or discovery. And may include a motion to control an answer during the deposition. When taking an oral deposition, the party asking a question may complete the examination before moving for an order. All right. And then provides that if the motion is granted, the court must, after giving an opportunity to be heard, require the party or deponent whose conduct the motion. Okay. The party or attorney advising that conduct or both to pay the movement's responsible expenses or reasonable expenses incurred in making the motion, including attorney's fees. Okay. So this is cut and dry. This is absolutely cut and dry. The court should compel resumption of the deposition under proper conditions because the supervision was justified under Rule 30. Okay. The deposition was being conducted in bad faith by the debtor. Well, we know that. I'm still wondering why the child was even brought into the courtroom. Now, correct me if I'm wrong, guys. I'm pretty sure that's what was said, that the child was literally brought into the courtroom. I know that they said that Crook and the child were in another room, but at one point in time, wasn't she in the actual courtroom at one point in time? I can't remember. Enlighten me, my friends. My four sons, good morning. How you doing? Welcome. Oh, flying wheels. What you got to say? If LP used a false name to sign adoption papers, can the adoption be void? I don't know. That's a good question. I mean, at this point in time, whatever happened with the child, okay, that has nothing to do with what's going on right now. Okay. That's a conversation for another day, but that is a good question, a very good question. Somebody needs to look into that. Me, I'm not looking into it, but there are other parties that are involved when it comes to the child that should look into it. And I'm not saying it's anybody in my chat, because we all know my rules. Stay away from these people. Don't contact anybody. Leave them alone. Let them do their thing. We do our thing. Jeremy doesn't need any of us, jeopardizing what he's doing. All right. The deposition was being conducted in bad faith by the debtor. The undersigned properly suspended our deposition under Federal Rule of Civil Procedure 30 on the grounds that the deposition was being conducted in bad faith. The rule permits party to move or terminate or limit the deposition on the ground that it is being conducted in bad faith or in a manner that unreasonably annoys, embarrasses, or oppresses the opponent or party. Here we go. It's like these rules are just keep repeating themselves. But yes, I get it. She got in trouble. Stop. The debtor's repeated interruptions. Okay, we've got that. The debtor's own counsel. Okay, we already read over that. The deposition may resume only by court order upon the undersigned's demand. The deposition was properly suspended pursuant to Rule 30. The court should enter an order permitting the deposition to resume under proper conditions. Those conditions should include a clear directive to the debtor that she must allow each question to be completed in its entirety before beginning to answer. Well, good luck with that. I don't know if that's going to work or not for them. A directive that the debtor must respond to the question asked and not volunteer information beyond the scope of the question, which means we don't need to know the 30 shades of gray. Okay, we just need to know a yes or a no, or that was my name or this is my name. We don't need to know the whole history of it. We just need to know the point blank answer. Oh, well. Oh, what you got to say, Grant? I believe Jeremy is the right as far as the legal matter, but I don't like how he presents himself online. Well, that's here nor there. That's your opinion, and everybody has that, and I welcome everybody's opinion. Jeremy's going to do what Jeremy wants to do. As far as what's going on with court and everything, that's all I'm interested in. I watch his storage units. That's all I watch. Well, I watch all of his stuff, but still, it's up to him how he wants to portray himself online. I'm not saying one thing good or bad about it. It's not my place to. All right, Mama Bear Leah, nighttime for bed wedding is completely different use or issue. What are you talking about here? Awake and alert during the day needs to be made fun. Screaming at a child for accidents is not right and will be very detrimental. Right, Mama Bear Leah? Right. There's been a lot of things said to that child on recordings that shouldn't have been said, but hey, I'm not her. Apparently, law enforcement doesn't care, or they would say something about it. But that's up to law enforcement, not up to me. Randy and Jeremy cry like little girls, and the court all the time. Oh, really? Really? Oh, I see you made it back. You're welcome to stay as long as you keep it pleasant. First time it's not. Guess what? You'll be gone. All right. Oh, a directive that the debtor must respond to the questions asked and not volunteer information beyond the scope of the question. And I don't see how Jeremy, that reminds me, how is Jeremy crying in court? Jeremy's never even had a chance to speak yet. Huh. How does that work? None of these hearings have actually gotten to the point to where he's allowed to present his side of it. So that's kind of odd. Yeah. Oh, a directive that the debtor must comply with all instructions from her counsel regarding proper deposition conduct. That ain't going to happen. You can't take people like that and change their ways. That they're just going to act the way they're going to act. A warning that any further disruptive conduct will result in immediate termination of the deposition and further sanctions, including potential contempt proceedings. Ooh, all right. I think that's the only way that it's going to get anything through their head is the contempt stuff. I think that she could fine them $1 million and they're not going to care. They're not going to care one bit. Now, that's just my opinion, guys. Oh, Big Al, what you got to say? That's why I was saying normally we don't ever hear a lot of those that she said was adding up, but they always throw a fit. Come back here. Because a sheriff's officer comes out with CPS, probably not gonna do anything, right? Well, as far as her CPS stuff goes, I don't care. It's none of my business. I didn't see anything, so I don't report anything. Unless I see it with my own two eyes, I don't do shit. I stay away from them. It's not my business or anybody else's business that don't see it. I wasn't in the courtroom. I didn't see anything or hear anything. So, I'm not going to go to any police. Through his attorney, you are so obtuse. It's hard to tell if it's intentional or you're just a retard. Well, looky there. He finally crossed the line. So see, where did he go? Let's go. Da, 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 da. Let's refresh real quick. Oh, here we go. Ba-bam. It's coming up. Oh, where did it go? Where is this chucklehead at? He's on YouTube. All right. Oh, there he is. Oh, and now you can join the rest of your fools on the no-fly list. Have a nice day. The court's prior order already found that the debtor disregarded discovery obligations and that sanctions serve the purpose of deterring similar conduct and vindicating and integrity of the discovery process. An order compelling resumption of the specific court or conduct requirements is necessary to ensure that the deposition can proceed to completion. I think that's the only way that you're going to get it. I think that's the only way you're going to pound any sense into her head is putting her in contempt of court and putting her in jail for a few days. I think that's the only way it's going to sink into her. I don't think fining her or sanctioning her is going to do one bit of good. Tell me if I'm wrong, guys. Tell me if I'm wrong. All right, who we got going on? What do we got here? Where did it go? I just saw something. Where is it? She called the court and CPS on herself. For fuck's sake. Sorry. I'm getting a little ahead. No, you're fine, Mama Bear Leah. I agree with you. I 100% agree with you. I'm shocked that any of the court people, bailiffs or any of that, I'm shocked that they aren't the ones that called it in. Who knows? I don't know who called it in. Flying wheels, you'd only type the truth. The rest of us are thinking, right? Sorry, you can't use the R word here. No, Robin, they made it to the no-fly list, so they can have fun over there. Go create you another channel and come on back. Round man, she gets jail time. Will they take HG then? I don't know. Round man. She says that her sister, I think, is going to take the child if something like that happens. I'm not 100% sure. That's just what we heard in the grapevine. Whether that happens or not, I don't know. I don't have any clue. Sure don't. Oh, who else? I saw somebody else had something to say. CPS only goes to the front gate. We've seen it before. Right. She's learned that in the state of Florida, CPS can be told to stay off of your property unless they have a warrant. So if they want to come on the property, they have to do it the proper ways, which means they have to file with the courts to get a warrant to be allowed on the property. Lynette knows this. That's why she does not allow them on the property. And guys, that's not my words. That's her own words that she said many times over. Oh, I think Jeremy will always think before he speaks, where the others never do. They always change the story. All of this could have been avoided by respecting the C&D 3 years later. Here we are. Exactly, Spawn. Exactly. I agree with you, man. I sure do. William, well, I think Tug was right last night that she is in the mindset, right? She lost everything already. There's not anything else they can do to her. Well, she's been thinking like that for a very, very long time. I mean, think about it. She was served the proper way from a lawyer, a cease and desist, told to stop. What did that get her? It got her being taken to court in Ohio, where it gained her a special little protection order. She's been deemed a internet stalker and harasser. So they don't learn. They don't learn. It's repeated behavior over and over again. They didn't learn when they got the protection order against them. They didn't learn when they got the first contempt and they were ordered to pay fines. They didn't learn when they got the second contempt in order to pay fines. They've got a third contempt we're still waiting on the judge to rule on. Obviously, they're not learning anything, or they just don't care. Sarasota Beach Bum, good morning. How you doing, my friend? How you doing? Mr. Coop, read my post about the adoption question. I posted a little ways back. Waving hands. Okay. And that was Kathleen. Let me go see if I can find it, Kathleen. I'll see, girly girl. Now, don't hold me to it. I might not be able to find it. Got Nanny there. Nanny again. Be nice. Feather be nice. They don't have to worry about being nice anymore. They can go be mean somewhere else. Here we go. I think this is the one you're talking about. Just looked it up. And yes, an adoption can be void if the person used a non-legal name to adopt said child, especially if it was used to hide their criminal background. I hope that's the one that you were asking me to look at. And I agree with that. Yeah, I do. But then again, guys, this is where I'm going to step in and ask each and every one of you, please do not contact any of these people or any agencies at all. Let Jeremy Hales handle it himself. Okay. We don't need to get involved in any of that stuff. Okay. I'm here to read documents and talk about them with you guys. As far as all of the other stuff with all of those CPS people and stuff like that, that's none of our business. We don't live there. We don't see what happens or what goes on. So please just take my advice and do not contact any of these people. All right, Kathleen says, that's it. Right on, right on. Okay, I found it. All right, let's get on with this thing. B, the court should impose sanctions under Rule 30 because the debtor impeded, delayed, and frustrated the fair examination of the deponent. I like that. Frustrated. Oh, the debtor's conduct falls squarely within Rule 30. Federal Rule Civil Procedure 30 authorizes the court. Okay, we know it authorizes the court for sanctions. The debtor repeatedly interrupted the undersigned. Okay, we got it, Randy. Again. All right, we got it. We got it. She interrupted. All right. The rule does not require that the obstructed conduct be directed by the counsel or that the counsel participate in the obstruction. Applies to the person who impedes, delays, frustrates the fair examination. The debtor is the person whose conduct violated the rule, and the debtor should bear the consequences. I agree with you. 2, opposing counsel's good faith effort do not excuse the debtor's conduct. No, it doesn't. Now I wonder, Saran Wrap was doing everything within his power to get her under control. I don't really care for the guy. I mean, as far as I'm concerned, he's just trying to do his job. But can you hold him responsible for her behavior? Because it sounds to me that he went above and beyond trying to control her and the way she was acting. So you guys in the chat, let me know. You think Saran Wrap should get in any trouble for this? I don't. I mean, according to Randy's motion here, and according to what Jeremy had to say and several other people, he literally tried to do his job. She just wouldn't allow him to do the job. If I were him, I would be going to the court saying, hey, I want off of this case. Please, judge, let me off. She's not going to listen. I'm here to do a job. I can't effectively do my job because of this person and the way they are. I would ask to be removed. That's just my opinion if I was him. Oh, what you got to say, Grant? The only people that win in this case are the lawyers. Even Lynette's attorney wins because there's Mama's is home, because it is a taxable write-off. Right on, Grant. I agree with you. Lawyers make a lot of money. I mean, and the sad part is in today's society, you have to have a lawyer if you are in court for any reason whatsoever. Trying to represent yourself pro se without a legal background, you're just begging for disaster. That's just my opinion. Okay, what do we got here? Hey, we got 395 people in here, so please, if you don't mind, hit the like button. Teach old Screw Tube to throw us out into the interwebs. And for everybody on replay, please hit that like button. Teach old Screw Tube to throw us out into the interwebs. And if you're not following us on Rumble, you need to be. You need to be. So let me see if I still got that. Here is the link to Nope, that's not the link to Rumble. Yeah, it was. Dang it. Let me go get the link for Rumble. I'll post it in the chat so all you fine folks can come join us on Rumble. Okay. Coop. All right. Copy. And here we go. So if you're not following us on Rumble, you need to be. I do go over there ever so often, but it is a good way to have a backup plan. I just posted it in the chat, so please go over and join us on Rumble, guys. All right. Let's get back to this. The debtor's attorney made good faith efforts to control his client's conduct. Counsel took 3 off-the-record breaks to speak with debtor and repeatedly instructed debtor to to stop interrupting. Debtor on the record to stop interrupting. Wow. Oh, you beat me to it again, Mr. Cube. Got you, girly girl. Well, the cool thing is I use Restream to stream out on multiple platforms. So I can post the link on Restream's chat and it goes everywhere. But thank you, Mercedes and Nanny and Nancy and all of you guys, all my mods. Thank you so much for taking care of me out there in cyber world. Who else do we got here? William says, no, I don't think he should be held liable, but he will be, William says. My friend is a lawyer, and he always says lawyers can't even afford lawyers, right? Right? Thank you, Mama Bear Leah. Good comment, girly girl. Okay, let's see. We got to be good. What you got to say? I think the SA claims are just part of the grift. Poor me. Yeah, you're probably right. You're right. They've done. See, this is what a lot of people don't understand. Hey, there's Faves. I always grab it before the stream because for Megan's Lives. Right on. Thank you so much, Faves. Let me see. No, it's unlocked. All right. All righty. We'll get back to it. Let's see. Counsel took 3. Okay, we got there. The creditor acknowledges these good faith efforts and does not seek sanctions against opposing counsel. Good, Randy. Good on you, man. Good on you. Good on you. However, the fact that opposing counsel attempted to correct debtor's conduct does not excuse the debtor's behavior or eliminate the need for sanctions. To the contrary, the fact that the debtor ignored her own attorney's repeated instructions demonstrates the deliberate and willful nature of the obstruction. A witness cannot repeatedly disrupt the proceedings and then avoid sanctions simply because her attorney tried to unnecessarily or unsuccessfully to stop the deposition. Or the you guys got it. The court's prior order in this case recognizes that the discovery obligations are imposed on the parties themselves, not merely on their counsel. The court found that the debtor's failure to notify the creditor of the scheduling conflict and her last-minute motion for protective order were inexhaustible, even though the debtor was represented by counsel. Summarily, the debtor's disruptive conduct at the deposition is sanctionable, even though her counsel attempted to correct it. Wow. So let's see what you guys got to have to say over here. We got Grant. What you got to say? I think this has harmed George more than anyone else. prayers her way. Right. You guys keep George in your thoughts and prayers. If you pray, pray for her. If you don't, keep her in your thoughts. Right on. Lynette should be charged for screaming that everyone that comes near the child has that's why I ain't going nowhere near them people, Nancy. Hell no. I'm not getting anywhere close to those people. The minute you make that woman mad, I don't care if you're a male or female, she is accusing you of things that you didn't do. Now, according to what's going on with John, I don't know whether he did it or not. But as far as I know, Jeremy's never been within 10 feet of that child. So I don't understand how they can make the claims that he's harming the child in any way. But hey, then again, you've got a crazy person. Oh, I just pray that Jeremy finds peace after all of this. No one should go through what he has. The town courts, county sheriff, and the people involved in the case have all done harm to him. Yeah, you're exactly right, Grant. You're exactly right. I will tell you this, that Jeremy and George, the brief time that I've met them in person, they try to deal with it with humor as best they can. But I can tell you right now, as many court cases and as many things as he's got going on, this is bound to get under their skin. It's just no way possible it's not. I wish that they found some harmony and some happiness, but it's going to take time. Oh, what you got to say, Maud? Crook shown enough disgusting behavior online, right? He is a vile human being, very vile human being. Okay, what else we got here? Suppose CPS was upset about Tubetown. CPS upset about Tubetown? What the hell does Tubetown have to do with anything with what's across the street? So people in America are not allowed to have yard ornaments in their yard? Is that what CPS is saying? I don't understand why Tubetown has anything to do with CPS. Blows my mind. All right. The creditor is entitled to reasonable attorney's fees, court reporter fees, and costs. Rule 30B authorizes the court to impose sanctions, including the reasonable expenses and attorney fees incurred by any party on the person who impedes, delays, frustrates the fair examination. The creditor has incurred substantial expenses as a result of debtor's conduct, including attorney's fees for 2.5 hours spent at the aborted deposition on July 7th, 2026, attorney's fees for preparing for the deposition, court reporter appearance fees for July 7th, 2026 deposition, court reporter fees for the transcripts of the aborted deposition, attorney's fees for the time spent drafting this motion and supporting materials, attorney's fees for any hearing on this motion. The creditor will submit an affidavit of attorney's fees and costs, detailing these expenses with the court should order the debtor to pay all reasonable expenses incurred as a result of her obstructive conduct. I believe it. She should. But then again, doesn't matter how much money is imposed on her in fines or fees. She ain't paying it. This is the second deposition that has failed to proceed due to debtor's conduct. This is not the first time the debtor has obstructed and disrupted a deposition. The debtor, engaged in the same disruptive behavior during a prior deposition with the undersigned in a state court matter. The debtor The debtor's pattern of obstruction demonstrates that she has no intention of complying with her discovery obligations, absent the threat of substantial sanctions. Yeah, well, it doesn't even threat of substantial. It's not going to matter how much they threaten her or how much she gets sanctioned. She's not going to pay it. She doesn't care. It's going to take jail time to stop this bad behavior. And then I don't even think it's going to fully stop it. Oh, what you got to say, Sharon? Good morning, girly girl. Element of he takes no responsibility for what she says or does, which is behavioral disorder. Gotcha. Janice, what you got to say? I'm over here now, taking a break from cutting grass. Oh, wow, man, stay cool out there. It is hot. It is hot. Stay cool out there. Going to make a couple of bracelets for our Cancer 5K. Oh, cool beans. Right on. What kind of bracelets are you making, Janice? Are they paracord or what are you making them out of? Let me know. I'm interested in that kind of stuff. Okay, what you got to say, Ben? CPT or CPS has nothing to do with Toontown. But if Lynette and John emotionally abuse the child with undue stress because they hate Tubetown, then Lynette and John are not adult enough to stop complaining, right? You make a good point. Travis and Julia are just regular peeps. Just because she needs to control everyone is why she hates everyone. Because if you're like me or Travis, we do not comply. Right on, stats. Right on. All right. Moreover, this is the second deposition in this adversary proceeding that has failed to proceed to completion due to debtor's conduct. The first deposition was aborted because debtor failed to appear after filing an untimely and unjustified motion for protection order. The court has already sanctioned the debtor for that misconduct. Now the second deposition has been suspended due to debtor's deliberate. Again, Randy's. I don't know why he keeps repeating himself. I'm not a lawyer, guys, so this might be normal. I don't know. I'm pretty sure that he's having to explain this for each of these rules, I guess. These rules of civil procedure, I don't know. I have no idea what's going on with all this. I don't know why he keeps repeating himself, but anyhow, according to D, I think it's because each procedure he has to go into detail with what is this civil procedure thing. Where is it at? Oh, where'd it go? Dang it. The civil procedure stuff that he keeps quoting. Oh, there it is. Rule 30B, this stuff. He has to, each time he quotes one of those, he has to give an example of it. Moreover, this second deposition, okay, we got there. The pattern of obstruction requires escalating sanctions to ensure compliance. We got there. The court's prior award of attorney's fees. We got there. The court should impose further sanctions for bad faith obstruction of the discovery process. The debtor has twice prevented the completion of the deposition. First, by failing to appear after filing an unjustified motion. Okay, we got there. The pattern of obstruction demonstrates a deliberate strategy to avoid giving testimony and to frustrate the creditor's ability to conduct discovery. And that is a 100% true statement, I think. 100%. I do believe she is doing this 100% deliberately. And I think that all of this crap is being put in her head from outside forces. I do believe. I mean, you got a lot of crazy stuff going on. A lot. The debtor's conduct is not merely careless or neglect. It is willful and deliberate. The debtor ignored her own attorney's repeated instructions and persisted in disruptive behavior despite multiple opportunities to correct her conduct. Additionally, sanctions are necessary. Now, I wonder, sanctions and attorney's fees. Well, we know Jeremy pays all of his fees. The minute he gets billed, he pays them, I do believe. I've never seen it, but I'm pretty sure that he pays his bills as soon as he gets a bill, he pays it. So that means she owes Jeremy attorney's fees and sanctions. Huh. I guess that could be. Yeah. The debtor has now twice obstructed the completion of her deposition. The court's prior order granting entitlement to attorney's fees and cost was insufficient to deter the debtor's continued misconduct. Right here. This is interesting. The court's prior granting entitlement to attorney's fees and costs was insufficient to debtor's continued misconduct. So is Randy asking the court to go farther instead of just sanctions and attorney's fees? Is he asking them for maybe contempt of court as well? Oh, that could be. He could be putting a little twinkle in the judge's eyes saying, hey, look, you can sanction her or hit her with a lawyer's fees all you want. She's not going to change. Could be. I don't know. Could be. All right. Additional sanctions are necessary to assure that the debtor complies with the court orders and her discovery obligations. Appropriate additional sanctions may include an order requiring the debtor to pay a monetary penalty into the court registry. Whoa, here we go. An order precluding the debtor from interrupting certain evidence or ascertaining certain defenses if she continues to obstruct discovery. An order finding the debtor in contempt of court. There we go. Contempt of court. There it is. If she engages in any further disruptive conduct at the resumed deposition. There we go. He's asking. I wonder if the judge will do it. An order requiring the debtor to pay double or the reasonable attorney's fees, double or triple or treble. Oh, wow. Well, she can be ordered to pay, like I said, $1 million. She ain't paying shit. And costs incurred by the creditor as a result of the obstruction conduct. Wow. The court has broad discretion to fashion sanctions appropriate to the misconduct, given the pattern of obstruction and the debtor's deliberate defense of her own attorney's instructions. Right? Wow. This is getting interesting. Let's see what you guys got to say over here. Nanny says you can be found in contempt in a depot, right? Definitely. They're asking to have her put in jail, Big Al says. I would be pushing for that. First and foremost, I would want a judge in the courtroom, because you remember when Jeremy and Bubbles both went at it, okay? And Bolito made them come all the way to Pensacola and hold the deposition in front of him. I do believe that this judge here should do the same thing. I think that Lynette should go before the judge. Now, Jeremy hasn't done anything wrong. He hasn't even said a word, okay, except maybe give his name. So he hasn't done anything disruptive. Randy will be in the courtroom along with Dennis, I do believe. But I think the next one should be scheduled in front of the judge. And I'm going to guarantee the judge is not going to be happy about that. The judge has got far more important things to do than rule over some nutbag that can't keep her mouth shut and do what's proper. Ha! That's just my opinion, guys, and I'm sticking with it. Yeah. Oh, hey, Kevin, how you doing? Where did it go? I was at JH when this was going down, beginning. I was on a live threat by people who we met frauding in this. JH let me ask his securities. I wished him luck. Happy Olap didn't instead. Okay, gotcha. Oh, what you got? When you gift for your tax bill, electric bill, and everything else, why would she worry about fines? Right, Nanny? Right? Who else we got up here? All right. Get back to it. Let's see. Debtor's conduct in this case represents a deliberate attempt to avoid giving testimony and to frustrate the creditor's ability to pursue his claims. Ooh. The debtor has now twice prevented the completion of her deposition through her own misconduct. Okay, we got it, Randy. The implementation of sanctions serves several important policy goals. First, it commensurates the injured party for the time and expense wasted as a result of the obstruction. Second, it deters further misconduct by imposing a cost on obstructive conduct. Okay, man, I'm getting tired, guys, if you can't tell. Third, it vindicates the of the discovery process and reinforces the expectation that parties will comply with their obligations in good faith. Let's see. Conclusion. All right. The debtor has twice obstructed. Okay, we know she's twice constructed. The debtor's conduct violates federal law. Okay, we got that. Certificate of counsel pursuant to all of this. Wherefore, creditor Jeremy, this is the meat and potatoes right here. Jeremy Hales respectfully requests that the courts enter an order compelling the resumption of the deposition of debtor LMNOP Preston under proper conditions, including specific directives regarding the debtor's conduct and a warning that any further disruptive behavior will result in immediate termination and further sanctions. Cool. All right. Impose cost shifting sanctions under Federal Rule of Civil Procedure 30, requiring the debtor to pay creditors reasonable attorney's fees, court reporter appearance fees, and all other reasonable expenses incurred as a result of the aborted deposition on July 7, 2026, and time spent drafting this motion. Impose further sanctions to debtor further misconduct or future misconduct, and vindicate the integrity of the discovery process, including but not limited to the monetary penalties, evidentiary preclusions, or a finding of contempt if the debtor engages in any further disruptive conduct. All right. Direct the creditor, okay, to file an affidavit of the attorney's fees and cost. within 14 days of the date of the court's order, and permit the debtor to respond within 7 days thereafter. Schedule a hearing on the amount of attorney's fees and cost if the parties are unable to reach an agreement after conferring in good faith, and grant such other and further relief as the courts deem just and proper. And there we go, guys and gals. There you have it, right there in a nutshell. Holy cow, that is something else. Wow. Randy, the judge reads all of this. And when the judge gets done reading all of this, I don't see how she could not take all these recommendations to heart. So now we are done with that. So I'm going to get this off the screen, and I'm going to talk with you guys about everything that we just went over. Some of it I skipped through, guys, because it was repetitive. But hey, you guys all get the gist. What you got to say, Grant? Adverse interference. This means the court will legally assume that whatever information you are hiding would have been deeply damaging to your position, usually resulting in the court ruling in favor. Right. So if Randy asks her, is your name blah, 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 and she says nothing, or she goes off on some other tangent, Randy can the courts will just say, okay, Randy was right. It's blah, 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 blah. Let's see. Screenshot this. Olaf is hilarious. Stats. She is so good at what she does. Music biz. Marty. Okay. Gotcha. Kevin, what you got to say? She will never pay anything to get her attention. You need to put her in a jail cell, right? Yeah, I agree 100%. I've been saying that all day. That's the only thing that's going to wake them up. Because the thought and the idea of that child, her being removed from that child and being placed in jail for contempt, that's got to scare the living bejesus out of her. Okay. She has kept that child so secluded and so hidden from the world that the idea of her getting put in jail has got to just terrify the shit out of her. Maybe that'll wake her up. Who knows? I hope it does. I hope it wakes her up, but, the full motion is in Discord if you want to read. Blah, blah, blah. Thank you so much. Thank you, Nanny. Hey, there's Polymompicus. What you got to say? Interference video explains the concept if you are interested. Is it one of your music videos, or what is it? Polymompicus. Let's go see. Where's he at? Tone. All right. Let's go see. Bam. Oh. Oh, okay. Well, I'm going to share this to the audience, Rickles, because I've watched this one before, and I think the audience could learn a lot from it. So I'm going to share it for you in the chat again. And I urge all you guys to go check it out because it is very, very informative. I liked it when I saw it the first time. Bam! Get the link, and then we hit this, and then I just paste, and then I go back. Come on now. Come on. Work with me. Fingers, work with me. All right, there you go. I've posted it both in Rumble and YouTube. You guys go check out Polymompicus' video. It explains a lot of what we talked about today. It sure does. Tom, what you got to say? We might be looking at a long prison sentence if she keeps up her contempt. If not, a life. No, I don't think the courts will go that far, Tom. Contempt, she may see, a day or 2 days if it goes that far. But now I have seen judges in the past that have given people contempt, and when he gives them, say, 60 days and they raise Cain, he gives them another 60 days. I've seen some of these people piss the judge off so much, they just kept adding to where they wound up with a damn year in jail over contempt. I don't think it would go that far with Lynette. I think if the judge told her, hey, I'm going to hold you in contempt, and she saw that plaintiff walking towards her, not plaintiff, that bailiff walking towards her, I think that would snap her right out of that crap. I think it would give her an attitude adjustment and she would stop. I could be wrong. But yeah, the fear of going to jail, I think that's the only thing that's going to snap her back out into reality. Just her being fined or sanctioned, I don't think that's going to do anything at all to stop her. I don't. I don't believe LP. She wants best for that child. Why else saddle her up with a dumb as a come back here legacy and force to take care of the turtles and be struck in the hole, right? I hear you. The only thing with that child should be encouragement to seek out whatever in life that makes them happy. Who knows? By the time this kid turns 16, she might not want anything to do with the turtles. She might want to be a lawyer. She might want to be a doctor. She might want to be a scientist. Who knows? The fact that people encourage their children to go off and do what they are happy doing, that's the only thing that should be taught to this child. But hey, I'm not a parent. I'm not a guardian of this child, so it's not my call. She needs long-term treatment for her mental health issues, in my opinion. That should be part of the agreement and to move. Oh, right, Grant? Got you, Grant. I got you. She always gets, what you got to say, M. Marsh? She always gets by using poor, disabled, elderly. You're right. Well, she's going to run up against the judge one of these days. They're not going to listen to that shit. They're not going to pay attention to it. They're going to sock her with some steep fines and possibly jail time. Could you imagine if Crook was in the courtroom? We all hear about all of the crazy stuff that Lynette does in the courtroom. Could you imagine if Crook is in there and if he's being deposed? He's going to be 10 times worse. Stats. No man should be called cool for being frauded just because you drool over him, right? Right, Stats? Who else we got up here? Who else got something to say? Screenshot this. What you got to say? LP has lived a rough life. I would be shocked if she makes it until the child is 16. Well, I don't know. I don't know anything about her health. I don't wish anything bad on her, justice, yes. Health issues, no. I don't wish that on anybody. I want everybody to be happy and healthy. All right, Patrick, what you got to say? Number 3 days in jail will be all that is needed for CPS to get custody of kid and save her, unless she's got another family member, that the kid goes to. I do know if she gets picked up, police will put her in family services hands if there's no one immediately to take it. Now, if her sister drives up, they might turn the child over to the sister. But if the sister is not here and they pick her up, the child will go into family services. Because I don't think John's allowed to have her. I don't know. I'm only going off of what Lynette has said. Okay. As from what Lynette has said, he's not allowed to be in the same dwelling as the child. Hence why they supposedly live in two different, things. Custody of the kid and save her. A contempt imprisonment is the quickest way for Harley to get into custody. Right. All right, what else we got here? Seagirl Fed 1 would have been done 2 years ago if 2 L's would have kept her nose out of JH business. I agree with you. But that's all of this is stage, derail. Tracy Spencer, what you got to say? This child has no education. What are her choices when she grows up? Michelle says, or Lynette says that she's teaching the kid, she's homeschooling the kid. I don't know one way or the other. I can't tell you whether she is or where she isn't. I hope she is. I pray she is. But whether she is or not, I cannot comment on that because I do not know. What you got to say? Priority is to have the child put with family in a warm, clean home with all the love she can get. And Lynette should be put in an institution. Oh, in an institution to help her with her behavior. I agree with you, Spawn. I agree with you. All right, guys and gals, boys and girls, it is that time of day again. Oh, man, it's been a long one today, but I've bared with it all by myself today. I had fun with you guys. You guys all know we're on Monday through Friday from 11 a.m. Eastern Standard Time to around 1 o'clock in the afternoon or so. I've enjoyed each and every one of you coming and hanging out with me today. Thank you for all of the support that you guys show. It means a lot. Please make sure hit the like button on your way out or on your way in. If you're on replay, please hit the like button. If you guys are not following us on Rumble, you need to be. The link will be in the chat somewhere. So come join us over there. Follow us over there. And with that being said, my friends, you guys all have a wonderful weekend. I know I am. We're going to try out the new cast net. We're going to go fishing up around Fort DeSoto. So you guys have a safe and happy weekend. I will